accused number 2 and 6.
Morning, my lady.
Morning. I read the judgment of Lady Prinsloo yesterday, and there was an indication that Mr. Mororwa is appearing for you.
He was only appearing in that matter. We have not yet finalized our instructions to him as regards the criminal trial.
Yet.
Yes, I have, my lady. Bundle of documents.
Yes.
By the outlook on the pages, it appears that it may be in excess of 60,000.
I was made. It is about 100,000.
Yes, in excess, because it was a rudimentary outlook on what I received. I still have to consider the indictment and the record in respect of the case up to date, from what has been happening, per se.
Yes, I've filled off the February of this year.
February.
Yes, a number of trial dates were preserved, stretching from August of this year through to December of next year.
Lady, I haven't even properly consulted, but the other aspect is also I have not engaged my colleagues for the state to at least indicate the reserved dates so that I can then I'll get those dates, my lady, and then I'll have to reconcile my diary to be able to attend, to be in attendance, after I've obviously considered the disclosure and the relevant records, and after I've appraised myself and consulted with the accused number 1.
Thank you.
Please, my lady.
Mr. Shanghala. Morning.
Good morning, Judge.
I see in your application that you brought, in terms of Section 87, that the parties are noted as the state and then the various accused persons.
Yes, indeed, Judge.
Just for convenience sake, we will then continue with citing the parties as such, as being the state and accused persons.
Thank you, Judge.
You may then also proceed, Mr. Marandetsi, unless there's something else you want to, any practical matters that must be sorted out.
My lady, I would just suggest maybe we dispose of the parties who are not party to this application. Then we can.
Yes, I've not received any request.
Thank you, my lady.
Mr. Ilago,
My lady?
would you like to stay in attendance?
It's my first appearance. I'm not sure whether it may be required. I do not want to say that I must leave and then what transpires in court, I may need to get instructions. So I will remain, my lady.
You will remain, Mr. McNally?
I'll remain in attendance, my lady. Thank you.
Yes, the court, please, my lady.
Thank you. Mr. Shanghala?
I take it, Judge, that you mean that I can then proceed with the arguments for the application?
Yes.
All right. I've prepared a set of heads I would like to hand up to the court.
May I do so?
Unfortunately, I couldn't make copies. Where should I go? Oh, over there. My apologies, Judge.
Did you avail the state of a copy?
No, if we can make a copy for them, I wouldn't mind, but I couldn't make a copy. No, my whole train.
Mr. Lago, while we are waiting, is there any indication from your side how long you will need to go through the disclosure? The next trial date that has been set down is the 8th to the 19th of September.
My lady, from an educated guess, factoring in not just the perusing but also consulting, I'm looking at about 6 months to be able to know how far I am with this very large record.
Yes, that will not be acceptable.
Yeah, like I said, it's an educated guess, my lady, looking at what is before me. But it's very difficult. I would be in a position to inform the court on the next appearance what my progress has been with going through the entire record, my lady. But to commit and say that I'll be ready by September or October, it's...
Do you have your diary with you?
No, my lady. I don't have it with me. I didn't even know that there were trial dates, but I can source it while we are still seated and I can be able to inform the court.
Maybe I can then just give you this year's date. It is the 8th to the 19th of September. The court would appreciate that.
May it please you.
And then also the 10th to 21st of November.
1st November.
And then the 1st to the 5th of December. Those are the dates for this year.
Please you, my lady.
If you maybe can peruse your diary that you say you can do now, and just give an indication to the court whether you are available for that date.
I'll do so, my lady.
If you have accepted this brief, I think it goes without saying that this case will have to be prioritized.
Indeed so, my lady.
In your diary.
Indeed so, my lady.
Okay.
Please.
Mr. Marondetse, is it in order if we continue while we are waiting for the copies, or would you like to have a copy of the heads of argument before we proceed? We can just catch up.
We'll see what the heads of argument are like. If they are already decided, maybe we might ask for, after it's finished, we may ask for 20 or 30 minutes to consider what will be decided.
Yes. Did you likewise prepare heads of argument?
But that is like, I indicated I was in court the whole time.
So you will only address the court?
Yeah.
Yes, no, that's fine. Thank you. Mr. Shanghala, you may then proceed.
Yes. Timely. Judge, may I request for at least 45 minutes to just take you through? You will have noted that the documents we have filed with you, the two affidavits, are quite voluminous. Well, in context to the application.
Yes,
Thank you, Judge.
you may proceed.
Judge, the application is an application for disclosure. It is based on Section 87 being the closest section in the CPA that affords applicants or affords accused persons disclosure. The rules of the High Court, unfortunately, only contain one rule, Rule 114, that deals with criminal matters. Whenever we have tried to incorporate or bring applications based on the rules of the court, the state has always indicated that we are incorporating civil rules into the criminal stream, even though judgments are being churned out by the High Court to say that the High Court is the High Court and streams are merely allows the court to do its work. So the notice of motion has essentially six paragraphs that seek the disclosure. In paragraph 2.1, we seek an updated and corrected indictment, which they've agreed to provide us, and they have provided us the indictment, a physical copy. I've requested for an electronic copy. I'm still waiting for that. Hard copies of the bundles. The 2 weeks are still running out, and then hopefully we'll get the disclosed, the bundles that have been disclosed. Hard copies of the documents specifically mentioned in paragraph 2.3. In paragraph 2.4, we seek the bilateral agreements, but we now know from the PG who's made the concession that, in fact, there are no bilateral agreements with those countries. In paragraph 2.5, we seek documentation that proves compliance with the provisions of the International Cooperation in Criminal Matters Act of 2000 in respect of the mutual legal assistance requests that were done. And in paragraph 2.6, we seek the responses from those countries. So a full disclosure would obviously then entail what countries, whether they are listed in the schedule or not, because there are other countries in which, from the affidavits of matters ancillary to this case, it has become clear that the state had gone to request documentation. Then we request the court to order that the above documents are made available, including the report which would have been generated by Section 83 of the CP, of the POCA. Section 83 of the POCA mandates or authorizes the Inspector General to authorize police officers or direct police officers to conduct an investigation, and then once he has received the report, he would then make a determination to send to the PG. Now, then there's the issue of Deloitte. Deloitte was appointed with the concurrence of the Prime Minister. We don't have the letter of appointment of Deloitte. We have the concurrence of the Prime Minister. So we'd like to see that letter. What does it say? There's a motivation done to the Prime Minister, why they would be appointed. From the Deloitte report, take the court through to all those documents and explain why they're relevant. Suddenly, the terms of reference have changed. We want to understand why, what actually transpired. And then there's a document called Icelandic 2022. It's a mutual evaluation report on Namibia. It says that Namibia an integrated investigation task force for this matter?
Maybe, Mr. Shanghala, we can just halt for a moment.
The Prosecutor General opposes. Judge, in my head, at page 5, I take you through why and on what basis we bring the application. I've already indicated to you that there's only one rule. We are saying that a fair trial cannot ensue without the disclosure being made. That's Article 12(1)(a) of the Namibian Constitution. I then refer you on page 6 to the case of the State versus Schultz. In that case, which was presided over by the Chief Justice then Mohamed Ndubuchena, the former Chief Justice of Zimbabwe, and then Leon, Acting Judge of Appeal, I'd like to just read for you the part that I've highlighted. If disclosure of statements of prosecution witnesses falls within the ambit of Article 12 of the Constitution, then such disclosures constitutes one of the important elements of a fair trial. It is therefore of no consequence that the Criminal Procedure Act does not have a provision for a general right of disclosure of materials in a police docket as submitted by Ms. Winson for the appellant. The right resides in Article 7 and 12 of the Constitution. So this puts to bed the argument by the state that Section 87 is not the proper section to bring the application. I could not find, Judge, a case that has overturned S versus Schultz in this respect. I then move on to what the judge says: in proper circumstances, disclosure is needed for an accused person to examine a charge so that in proper circumstances, move to quash the charge. And this is really the issue. This case, this application need not have been made now. Had we already, when we started, the presiding judge just allowed us to finish pretrial, we get access to the documentation, we look at them and exercise our rights, whether we challenge the charges, etc. But instead we were Deutsche Bahn rushed into a trial, into the taking of the pleas, and that is where we are. The Supreme Court in Schultz relied on and talked very much about and dissected the case of Shabalala and others versus the Attorney General of Transvaal and another. So what you had is, you had a case happening in 1995 in South Africa, and then in 1996, the Chief Justice Mohamed sat on both of these cases. So no wonder that there's congruity in the judgments and the jurisprudence that is derived therefrom. And in Shabalala, they put to bed the issue of that the case of RVs, a 1959 or is it 54 case that existed 54 in the appellate division. And it was a blanket docket privilege. Once privileged, always privileged, because the state is also entitled to privilege. The Schultz judgment holds that Steyn and other cases have of recent times been overtaken by new developments. And what are the new developments? Obviously the Constitution and the cases that came about to discuss this blanket docket and put it to bed. Considered in Shabalala, that case is an English judgment. I've quoted for you a part on page 7, which I want to read out. It was held that the prosecution should have provided the appellant with all statements The court was of the view that it made no difference whether the document took the form of witness statements or notes of an interview or a police officer's report. So this is really going to the crux of the issue. Disclosure for fair trial must include everything that ought to be disclosed. And I will get to a case that then tells you why. Obviously, this public interest immunity in England, I've just defined it for you. It needs to balance the interests of the accused and those of the state. Then the court then also decided to consider the case of R.V. Mauruf, which is another English case of 1992. And I've quoted a part that I would like to read out to you. A failure on the part of the prosecution to disclose the defense material documents or information which ought to have been disclosed may be a material procedural irregularity in the course of the trial, providing grounds for an appeal against conviction to be allowed. The duty of disclosure is not confined to prosecution counsel, but includes forensic scientists retained by the prosecution, and accordingly failure by a forensic scientist retained by the prosecution to disclose material which he knew might have some bearing on the offense charge and the surrounding circumstances of the case. I want to just emphasize the surrounding circumstances of a case may be a material irregularity in the course of the trial, providing grounds for an appeal against conviction to be allowed. Then on page 8 to 37 of my head, page 8, paragraph 2.12 of my heads, I then refer you to another case that was considered in Shabalala and Schultz. That's the case of R.V. Ward, a 1993 English case. And in paragraph 1 there, I quote a part, just a small part. It says, the prosecution's duty at common law to disclose to the defense that all relevant material includes, that is, to allow them to inspect the statements made and make copies unless there were good reasons for not doing so. Furthermore, the prosecution were under a duty which continued during the pre-trial and throughout the trial to disclose to the defense all relevant scientific material, whether it strengthened or weakened the prosecution case or assisted the defense case, and whether or not the defense made a specific request for disclosure. Pursuant to the duty to prosecution, the prosecution were required to make available the records of all relevant experiments and tests carried out by expert witnesses. I again also continue, taking from that case, another part from Ward, R.V. Ward, at 601J, where it says, it is of help to the accused to have the opportunity of considering all material evidence which the prosecution have gathered and from which the prosecution have made their own selection of evidence to be led. There may be in the police docket a piece of paper referring to some event, incident, time, or thing that will assist the accused in selecting material for his defense or reminding him of the time and the place where he was. This is of great importance. Now, dealing with this public interest immunity, the Supreme Court in Schultz at pages 28 and 27 say, I do not, however, share the view that the public interest immunity should be preferred in order to deny an accused a fair trial and justice. Open justice requires fairness to be evenly applied between the prosecution and the defense. Then the judge says, if before any trial the prosecution has in its possession documents or other evidential materials helpful to the defense case, but wants to claim public interest immunity, the defense should be informed of the fact, and the court should be asked to give direction or some ruling on the prosecution's claim to public interest immunity. The decision must be made by a judge. It would not be proper to allow the prosecution to decide which of the relevant materials should be denied to the accused on the grounds of public interest immunity. The prosecution should not be judge of their own case on the claim to immunity. The compelling reason for allowing the court to decide on documents or other materials claimed by the prosecution to be covered by public interest immunity is not unduly to compromise accused's right to a fair trial. That is important because in this case, we don't even know if they claim immunity. They don't claim immunity. They just say we're not entitled to it, without more. I have gone to read a case that was referred therein, in those cases, Shabalala and in Schultz. It's the case of R.V. Stinchcombe, and that is a Canadian case relating to a Calgary lawyer who was accused on counts of corruption and fraud as a trustee. That case is very instructive, and as we know, our Constitution and the Canadian provisions in their Bill of Rights are very similar. At page 333, paragraph A to J, in which Judge Sopinka of the Supreme Court of Canada, who authored the opinion, makes some lapidary remarks, I'd like to just lift some of them for the court. He says, "It is difficult to justify the position which clings to the notion that the Crown has no legal duty to disclose all relevant material." And then he continues, he says that the fruits of the investigation which are in the possession of counsel for the Crown are not the property of the Crown for use in securing a conviction, but the property of the public to be used to ensure that justice is done. So I'm entitled to this material. Then he continues, Justice now Ndubuchena, in short, referring to the sentiments of Justice Sopinka in the Canadian Stinchcombe case. He says at page 36, "But a trial cannot be just and balanced when the prosecution hides from the defense relevant materials of evidential importance in order to spring a surprise on the defense during the cross-examination." We believe this to be the case, and I will prove it, I will show you. Now, let me just turn to Shabalala a little bit, where Chief Justice Mohammed, at paragraph 26, I'm at page 11 of my heads, says the following. "What is perfectly clear from the provisions of the Constitution and the tenor and spirit of the Constitution, viewed historically and teleologically, is that the Constitution is not simply some kind of statutory codification of an acceptable or legitimate past. It retains from the past only what is defensible and represents a radical and decisive break from that part of the past which is unacceptable. It constitutes a decisive break from a culture of apartheid and racism to a constitutionally protected culture of openness and democracy and universal human rights for South Africans," just read Namibia in there, "of all ages, classes, and colors. There is a stark and dramatic contrast between the past in which Namibians were trapped and the future on which the Constitution is premised. The past was pervaded by inequality, authoritarianism, and repression. The aspiration of the future is based on what is justifiable in an open and democratic society based on freedom and equality. It is premised on a legal culture of accountability and transparency. The relevant provisions of the Constitution must therefore be interpreted so as to give effect to the purposes sought to be advanced by their enactment." That is now Article 12. He could have been speaking as if he was sitting in shorts. He later did come and speak, well, through Justice Ndubuchena, and it dovetails exactly what he said here. Then in Shabalala, he continues at paragraph 36. "The basic test in the present matter must be whether the right to a fair trial in terms of," you can just put in Article 12.1, "includes the right to have access to a police docket or the relevant part thereof. This is not a question which can be answered in the abstract. It is essentially a question to be answered having regard to the particular circumstances of each case. What a fair trial might require in a particular case depends on the circumstances, the simplicity of the case, either on the law or on the facts or both. The accused may, however, be entitled to have access to the relevant parts of the police docket, even in cases where the particularity furnished might be sufficient to enable the accused to understand the charge against him or her. But in the special circumstances of a particular case," and I underline and bolded that, "it might not enable the defense to prepare its own case sufficiently or to properly exercise its right to adduce and challenge evidence or identify witnesses able to contradict the assertions made by the state witnesses, or to focus properly on significant matters omitted by the state witnesses in their depositions. In other cases, which might include a substantial number of routine prosecutions in the inferior courts, there might be scant justification for allowing access to police dockets in order to ensure a fair trial for the accused." And then he goes on to give an accuse of a minor charge where over the weekend there was some kerfuffle, and then he says there might be ordinarily little sense in requiring copies of the whole docket to be prepared and available to the accused in order to dispose of such prosecutions. But we know that in the particular circumstances of this case, and this is a complicated case, we require the complete disclosure. The Shabalala court rejected the blanket docket privilege as unreasonable, unjustifiable in an open and democratic society, and is certainly not necessary. It cannot be raised here either, and the state doesn't. Now, taking a similar position to that taken in England, you see, the Shabalala court in paragraph 55 goes on to say that the court still retains a discretion. There may be circumstances where the non-disclosure of such statements might carry a reasonable risk that the accused may not receive a fair trial and might even be wrongly convicted. I'm saying that that risk exists here, and I will prove it. And even once the court finds that it will not order the disclosure, it's not a decision that's cast in stone. It can always be revisited at all times. Now, that is why we are here, and we remind the court of its obligations under Article 5, not just to protect and respect, but to enforce our rights. Now, what does the state say to our application? This is what the state says. I start outlining that at page 15 of my heads, Judge. The state says, and they make 8 positions clear in their papers. They say, it's the fault of the applicants that they've been detained for the past 5 years, 8 months, 3 weeks, 1 day. Not the prosecutor general, not the state. Applicants are causing delays to the trial. Then the second position they take is they say the application is nothing more but the consistent dilated modus operandi of applicants to delay the trial. Then the third position they take is that the application is premised on the wrong provision of the Criminal Procedure Act. Obviously, I've put to bed that notion now, or rather, the Supreme Court in Scholz has done that. Then the fourth position is they saying, yes, we received information. We received it from countries that are not listed in the schedule to the International Cooperation in Criminal Matters Act. We received it in the absence of a bilateral reciprocal agreement. But, and then this is the fifth position they take, the information that we've received, we're not going to share it with you. You're not entitled to it. The sixth position they take is that the information requested in paragraphs 4 and 5 apparently don't form part of the police investigation diary. They don't form part of the docket. You're not going to get it. That's position 6 and 7. And then position 8, the Deloitte report was not availed at the time because apparently there were issues that were yet to be resolved. Now, in the replying affidavit, Judge, I have dealt with pretty much these issues, and I give you reference to page 5 to 7 of the replying affidavit, paragraphs 11 to 25. I don't know if, well, I'll just continue to address them. I'm sure you did receive the replying affidavit.
Yes, I did.
Okay. Now, let me first deal with the legal issue that they say that we received them. We received them from a country without a bilateral agreement. There's nothing wrong with that. And by the way, you're not entitled to the information. What do they say? They say we relied on the United Nations Convention Against Transnational Organized Crime. We relied on the United Nations Convention Against Corruption. Therefore, we have that information, and that information is legally obtained. Now, Judge, there is something we need to look at, and that is, what does the law say about this particular issue? Article 144 contains a built-in proviso which fundamentally impacts any construction of that article. This is how the article reads. Unless otherwise provided by this Constitution or Act of Parliament. Let me just start again. Unless otherwise provided by this Constitution or Act of Parliament. If I just stop there, that's now the proviso. Unless otherwise provided for. So if you just start reading the general rules of public international law and international agreements binding upon Namibia under this Constitution shall form part of the law of Namibia, and you don't factor in that proviso, then you go wrong. And I think this is what happened. The question then is this: what does the Namibian constitution and legislation in Namibia provide? I take you to Article 1, Sub 1. The Republic of Namibia is hereby established as a sovereign state founded upon the rule of law. Then Sub-Article 6 of 1 says, this constitution shall be the supreme law of Namibia. Now, I take you to Article 63. It says, the National Assembly as the principal legislative authority, in and over Namibia shall have the power subject to this constitution to make and repeal laws. So it's not the UN that is the principal legislative authority. It's the Parliament, the National Assembly. The National Assembly shall have further the power and function subject to this constitution, and then in E, to agree to the ratification or accession to international agreements which have been negotiated and signed in terms of Article 32.3 hereof. The upshot of the above is the following. 1, Namibia is a sovereign state, no longer a UN trusteeship. 2, the Namibian constitution is the supreme law. 3, the rule of law applies, and it implies that administrative bodies derive their powers from law. 4, the National Assembly is the primary principal legislative body of the land, not the UN General Assembly. 5, international agreements can only apply subject to the ratification and accession thereof by the National Assembly. Now, what happens when then Parliament accedes to or ratifies an agreement? Which would trump the other? This is a question that must be determined with reliance to the Vienna Convention on the Law of Treaties and jurisprudence locally. Articles 31 and 32 of that convention provide for the general rules of interpretation that must be taken into account. And it then also, it includes the general rule, the context, and then supplementary means of interpretation, it includes the preparatory work, the circumstances that led to the conclusion, etc., etc. The jurisprudence locally, I refer the court to the Namibian Association of Medical Aid Funds and others versus Namibian Competition Commission in another Supreme Court case of 2017, which then, with approval, incorporates the principle we now know as the Endumeni principle, the Natal Joint Municipal Pension Fund versus Endumeni Municipality. And I think even though these were made in a criminal court, they apply because what that case says is, at paragraph 18, which has been incorporated by medical aid funds, it says, the present state of the law can be expressed as follows. Interpretation is the process of attributing meanings to the words used in a document, be it legislation, some other statutory instrument or contract, having regard to the context provided by reading and the particular provision or provisions in the light of the document as a whole, and the circumstances attendant upon its coming into existence. If I just interpose there, it will become clear why I'm reading this rudimentary principle that everybody understands. Whatever the nature of the document, consideration must be given to the language used in the light of the ordinary rules of grammar and syntax, the context in which the provision appears, the apparent purpose for which it was directed, and the material known to those responsible for its production. A sensible meaning to it is to be preferred to one that leads to insensible or unbusinesslike results or undermines the apparent purpose of the document. Then, read in context and having regard to the purpose and provision and the background to the preparation and the production of the document. I just highlighted those parts. Before we even consider the contents of the Convention on Transorganized Crime, Against Transorganized Crime, and Convention Against Corruption, UNCATOC and UNCAC, if you look at the legislative guide, so what the UNODC did is it went and produced a legislative guide. And in the guide, I've gone to look at the guide. It then this is what it says. It says that for both the UNCAOC and the UNCAC, the phrases, in accordance with their domestic law, or the phrase, in accordance with the fundamental principles of its domestic law, or in accordance with the fundamental principles of its system, legal system, or consistent with the domestic legal system, or to the greatest extent possible within its domestic legal system, or in conformity with the fundamental principles of their legal system, or in accordance with and subject to the provisions of its domestic law. These phrases appear 38 times in the UN Convention Against Corruption and 8 times in the UN Convention Against Transorganized Crime, which basically means you are subject to your domestic legislation. You can't just sit in an office and then say, I'm pulling the international legislation and I'm applying it. Then, and here's the problem, Judge, particularly when a non-elected official starts selecting provisions from international instruments. The PG is non-elected, the Director General of Anti-Corruption is non-elected, and then they say, I rely on article whatever in the convention. They don't even mention which article they rely on, but they say they rely on the convention. But we know which one they rely on. Here's the problem. Those conventions contain elective provisions. Some say you may do this, some say you may do the other. Hold a higher standard for countries that do hold a lower standard. Which one and where do they get the authority to make that election? Now, in a country like Namibia, which is a sovereign, we are what you call a weak monism or qualified monism in our approach to international law. And Judge, I have had the benefit, I don't think many people have had, I'm privileged to have had the benefit of a concept starting in an idea where countries discuss it. You go through the motions in your country, you convince your cabinet, you go to the international plane, you convince your colleagues. A UN committee is commenced, created, you deliberate an agreement, you even sit in committees, chair subcommittees, the convention or agreement becomes legislation. At the UN international plane, it's accepted. You come home, the process of ratification or accession thereto, you're involved in, you become a minister, and then you get to apply legislation. So I don't know how many people can talk about that experience, but I can give you the whole gamut. And it's that informs me. Now, what you cannot do is you cannot sit as an ACC in an office and write Diasis Dolly emails to one another. You know, you remember me from that conference we had? Yeah, send me that document, man. This is what has been happening. You can't do that. There are procedures to be followed. So what then happens is that the legislation comes. By the way, I had asked if the state would be bold enough to bring us the legal opinion that says that that is the case, that they can sit in the office and rely on that international agreement. I'd be very interested to see how that opinion has changed. And then, once it is adopted, and by the way, the UN system itself considers Namibia a dualist country. There is such a document. It is called the Legislative Guide. I've referred you to it. It'll take time, but the paragraph in question is paragraph 9 on page 9 in the manual. There's also a manual, sorry. There's a manual. So Namibia is a country that relies on reciprocity in its international relations.
It's the
Just a moment.
same.
Sorry, Mr. Shanghala, to interrupt you. I've lost you. Page 9 in which manual?
There's a manual on the implementation on the conventions. I can also avail that for the
Do you
court.
make reference to it in your submission?
I do that.
Where?
Page 22, paragraph 4.15. It flows over to page 23, footnote 30.
Okay, thank you.
And then so it's the same for extradition. It's the same for cooperation. Whether or not we are dualist or monist, we must give effect to the international agreements, acceded to or ratified, but we must adopt legislative measures. Now, the International Cooperation in Criminal Matters Act is that legislation of 2000. And that is, if you now go back to Article 144 that I was talking to, subject to the Constitution and the laws, it is now, any international agreement is now subject to the supremacy of the Constitution and what it says about Parliament being the principal legislator, and that legislation, which is the International Cooperation in Criminal Matters Act. Now, I refer you to a case of Thudi Nyane versus Edward. It's a case of the Supreme Court of 2012. It says, in the absence of any constitutional provision or act of Parliament contradicting the law or agreement in question, so international agreements or the convention, they have a similar force to legislation. In the absence of a constitutional provision or act of Parliament contradicting that law. Now, I want to refer you to Section 27 of the International Cooperation in Criminal Matters Act. I am at page 22 of my heads, paragraph 4.17. Section 27 of the International Cooperation in Criminal Matters says that the minister may enter into an agreement under 32.3, because that's a function of the president, and then it carries out those further provisions stated therein. Now, I say, therefore, it's unlawful to rely on provisions of the UNCAA TOC and the UNCAC in the absence of a reciprocal bilateral agreement or arrangement that existed. I'd like to bring your attention, Judge, to what I say at page 23 at the bottom in footnote 33. Section 27 of the International Cooperation in Criminal Matters Act says the agreement. But then I take you now to Section 30. Section 30 really says that if there were arrangements that existed, they wouldn't be prevented, abrogated, or derogated. Because to read it otherwise, and this is where now endumeni is important. Because if you look at the meaning of the word prevent, abrogate, and derogate, so to abrogate, to prevent means to stop something. To abrogate means to formally repeal or abolish something. To derogate means to detract from something. It must have been already existing. Otherwise, the absurdity is there's an International Cooperation in Criminal Matters Act, but you can still do things outside the scope of the legislation. That's why I referred you to the rule of law in Article 1, Sub 1, and the supremacy of the Constitution. And then Article 144, which says, unless otherwise, etc. So you cannot just sit in your office and say, there's an international convention, I rely on it. And all the cases where you have been determining in the High Court or Supreme Court reliance on an international instrument, it has always been to bolster the right of an individual, not the powers of the state. And the reason is simple: sovereignty. We are not a trusteeship of the UN anymore. So, If you take the provision, the position taken by the PG, and I'm moving on now to the non-disclosure issue, it amounts to one, an unconstitutional infringement upon my right in Article 18 to review actions taken by an administrative officer, office bearer. Two, it ousts judicial oversight over the functions of lower courts. Because you see, in the International Cooperation in Criminal Matters Act, a letter of request can be done under Section 2 by a lower court magistrate. But because information cannot be provided, now the court cannot access fully the information that it requires to review that decision. But then again, this is where endumeni is important. When they read Section 2A, which says that you don't need to provide the information, they forgot to read Section 6. Section 6 of the International Cooperation in Criminal Matters says, inspection of evidence obtained by letter of request. Where a letter of request is issued after proceedings have been instituted, the evidence so obtained, together with the record of the proceedings at the examination of the witness, shall be open to inspection by the parties to such proceedings. That is why it says, read the particular provision or provisions in light of the document as a whole. And then you look at what was intended. Context in law is everything, Judge. I've given you a case to that effect. I've cited for you Acti Bolachet Hassel and another versus Triomed in the Supreme Court of South Africa, Supreme Court of Appeal. I've also cited for you Fransman versus University of Namibia in the Supreme Court, a 2024 judgment. Context is everything. That's why I'm asking for the documents in total. And that's why when I read for you from Schultz and from Shabalala, the judge talks of you need to put the entirety. There may be a piece of paper there that helps me do something. But if it's kept away, then there's a risk that I may not get a fair trial. Now, I say that the PG misinterprets the provisions of the Namibian law relevant that I've cited to you. I asked her to bring the opinion of the AG. She hasn't. Maybe it will surface. The court can therefore disregard these positions taken. What is more, Judge, the state has already made disclosure. It's partial disclosure. And I'll just show you how farcical it is. I want to take you to the replying affidavit, Judge. I don't know if you have a hard copy.
Yes.
There's a document there, SESRAB. B. You see that, Mr. Margaret? B. No, B. SES-RAB. Have you found it, Judge? This is exactly my point. An unpaginated 165,000 disclosure. Look at 230 pages which I've given you, and you're struggling. It's been now 2 minutes. We are looking for a page.
What is the name of the document that you are referring to?
SESRAB. But Judge, if you don't mind, if you see my affidavit,
Yes.
go to the end of the affidavit itself. I've given you a table of annexes. Have you found that one?
Sorry, no, I do not have the annexes. I only have your affidavit, but I do have it on soft copy.
Okay. Have you found this one? Have you found the document?
It's actually on my other. Is it necessary? You can just refer me to it.
It is necessary because that is a document signed by Gladys Pickering, then the executive director of Justice. She writes to Paulus Noah, the then apparently acting director general of the ACC, that's what the letter says, on 7 June 2021. And then she says, we have attended a meeting with the Angolan delegation on 12 to 13 April 2021 at Oshakati High Court, chaired by the Prosecutor General Advocate Martha Imalwa. I want to stop there for a minute. Remember when I said that the PG had indicated in one of her affidavits that she was leading the investigation? That's what she said. Here's the evidence now. She's sitting in meetings where they are collecting evidence from Angola. Let's just continue. What does the letter say? During the meeting, we received the following documents from Angolan delegation. Volume 1 containing 207 pages. Volume 2, 469 pages. Volume 1, again, maybe it's a typo, 104 pages. Annexure 1 containing 104. Annexure 2 containing 146 pages. Annexure 3 containing 205 pages. Annexures 4, 5, 6, and 7 contain 200 pages each. That's 1,000. I give you the number there. 930 something pages. We have sought the services of Dr. Rego, PhD, a practicing sworn translator who has translated part of Volume 1 from the Portuguese to English language. That's the cover page, page 2, and page 140 to 208. He has also translated part of Volume 2 from Portuguese to English language, page 209 to 277, and page 459 to 470. It costs some 63,440. Now, context in law is everything. You get 1,900 pages, and you translate what? How many pages? And then you give it. You don't give it to us. We have to fight for it. 230 pages are the only pages translated. Then I want to refer you to the document SESRAC. That is an affidavit in support of an application in terms of Section 2 of the International Cooperation in Criminal Matters Act 2000, done by Andreas Ndeshipanda Kanyangela. It runs into some, I don't know how many pages, 10 pages. So when you say it cannot be provided, what do you mean? You've provided this. No, but they go further. Let me take you to the next document. It's document D. That is the letter by the magistrate. The magistrate is unnamed. We don't know. There's no name here. And Judge, I want to refer you to the last page of that document. It itself numbers itself as 64. When was this document obtained? Can you see that, Judge? 18 January 2023. But the song of Mr. Marondeze and the chorus of Mr. Litubezi has been, we have been ready. We have been ready. In 2023 only they get the information. Then I want to refer you to SESERAE, again in 2023. That's a letter to the Attorney General of Angola from the acting executive director of the Ministry of Justice. Now, I need to pause there and say that Namibia and Angola have a bilateral cooperation agreement. I've been part of the drafting. I saw it being signed. And I've lived to come and be a minister to implement it. We don't rely on the international cooperation in criminal matters. In fact, Judge, let me take you back. My apologies. Let me just quickly take you back to one of the documents I referred to you earlier, and that is the document that is, it could very well be this document, Judge. That is the document that is SESRA D. Please go to paragraph 10 of that document. Paragraph 10 of that document. You know, I wish I could just request Mr. Marandezes to stand up and read the paragraph. It's written in bold and in capital letters. Reciprocity. The request is made in accordance with the following instruments. And now we must look at the order of how they are cited. The Treaty on Mutual Legal Assistance between the Republic of Namibia and the Republic of Angola, signed on 24 October 2007. Then they go on to buttress now by the convention and then by the SADC protocol. Why did they need to list the treaty? Because particularly if the country is not listed, and Angola is listed. Angola is listed in the schedule. You need a treaty. What happens now when you do unlawful things? When you obtain information unlawfully? Whether you go and kick and kill people to get the information, or whether you go and sit in your office and send cis-dolly emails to one another, or start asking and doing things from countries that have no bilateral agreement with you? Fruits of a poison tree. Do we eat fruits of a poison tree? You could ask anybody with a IQ of 80. They'll tell you no. And that is why we need the information so that we may be able to, as Scholz says, Shabalala, Justice Mohammed, they say, so that I can challenge the charges. Now we understand the real reason why the state is so quick and in such a haste to start this prosecution, so that they can lock us in a prosecution of unlawfully obtained evidence. Then I take you to the document. Well, I'll come back to that. Judge, I told you that the claim has not that the state has not claimed any privilege. They just say, without more, you're not entitled to it. The state has not, in those 10 pages of the affidavit, adduced a shred of evidence to show why a full disclosure should not be ordered by the court. Mr. Marandezes must not come and testify from the prosecution bar. I will object. We had the opportunity to file affidavits. They chose 10 pages. They didn't bring any evidence. They don't claim any privilege. They just say you're not entitled. I've shown you what the constitutional interpretation by the Supreme Court is. We're entitled to it. It's not their property. It's the public property. But then there's another concerning aspect to this issue, is that evidence obtained from my residence has been disappeared. Apparently, the PG, Mr. Marandezes and co. went to the ACC, couldn't find it there. I'm not surprised, because the ACC, by the way, is supposed to be independent and impartial. I will read it to you from the Constitution in Article 94A. This is important, Judge. 94A.
Mr. Shanghala, sorry again to interrupt you. I just want some clarity because this is not the first time that I've come across in the record your reference to your personal property that it would appear is missing. Is it your contention that you need those documents to prepare your defense?
Yes, Judge. In fact, let me just explain to you. I was a member of the Central Committee of the Swapo Party. When the PG came to see us, I was able to show her that there was a document which involved myself and accused two. I showed her and I said, and it just makes sense, Judge, that if you could find documents of mine from the Ministry of Justice, if you could find documents of mine from my private interests, you would have found documents of mine from my SWAPO activities. Those documents do not support the case of the state. I'm not saying that the PG, Mr. Marondeze, Mr. Lutubezi, had anything to do with the disappearance of the documents. But I'm definitely saying that question marks should be asked around the conduct of the ACC. And I will give you enough reason to justify why I say so. I'm getting there. Those documents show that there was no conspiracy. How do you steal quota, by the way? I don't know. Those documents show why money was flowing into people's accounts, what they were doing with that money. Some of the evidence is there. They've disclosed some of it. Even to the extent of where jerseys were bought for the SWAPO Congress. But the nonsense case that I'm facing here has to be made a case. Yes, you're looking at me. Nonsense means no sense. And you combine it, nonsense. Makes no sense.
Are you stating that some of the documents that are contained in your personal SWAPO files have been disclosed to you?
No. What I'm saying is that, luckily, accused two could find one of the documents that related to him. Because of that, I could show the PG that I'm not lying. There is documents like this. She then went. She couldn't find them. They have been disappeared. And I will show you why I'm pointing fingers at the ACC. You will know, Judge, that it's not the first time in Namibia it has happened where the ACC has been used as an instrument weaponized against people. Justice Damaseb, the Deputy Chief Justice, wrote a judgment in which he said so. He said, be careful, don't be used. They know it. But if they want to be reminded, it's SV Hailulu, where the ACC was used by Karonda, now a member of parliament, to go after Vincent Hailulu, victimized him, weaponized the ACC. I'm saying the ACC has been weaponized in this case. It won't be the first time. It's not me that said it. I'm not JP Damaseb. Now, Judge, disclosure has been made in 4 tranches. I want to take you to page 15 of the founding affidavit. Page 15 of the founding affidavit, I've given you a table. At page 15, I give you a table that says, first disclosure was made in May 2021, when the court ordered make full disclosure. Did they make full disclosure? No. Then they gave us 80,000 pages. Then, I think it was Tamson Hatuikulipi who went for bail. Was it Ricardo Gustavo who went for bail? Then they realized that, oh goodness, he's saying things. Then they went to do investigation. Then they made a disclosure in June 2022. Then in 2023, Tamson Hatuikulipi goes for bail. Then they realize, oh, goodness me. Then they make disclosure again. The upshot is this, Judge. 90% of the summonses that have been issued in this case were issued after we were arrested. Because we've always been wondering, if an investigation started in 2014, what was so urgent that we had to be arrested on 27 November 2019, election day? Why? Again, they were being used. But I'll get there. I'll show you, Judge. Don't believe me yet. I'll show you. Then, 15 February 2024, after Mr. Marondeza had Valentine's dinner, he came to disclose more. 165,000 pages. They're not paginated. They don't want to paginate it. Yet we couldn't find a page in 230. Then you put the memory stick in here. Then you do that. How is this trial going to be conducted? Okay? In the founding affidavit, SETS, and the number there, 3, the document 3, is a disclosure. You see, Judge, we've been singing the song of disclose everything, disclose everything. In July, 25 July, they don't respond to us, they respond to Mr. Engelbrecht. It's zero radio silence from them. In July this year, these are people who have been ready apparently ever since Nangok to prosecute. Then they disclose, okay, Esau. They give us now the so-called referral in terms of Section 31, and then they give us the so-called concurrence. I'll explain to you why I'm saying these so-called things. I'm getting there. So we believe, Judge, just as disclosure was made in 25, if you order disclosure, more will come. Let me take you to SESRA in the replying affidavit. Are you there, Mr. Marondeza? SESRA in the replying affidavit. It's a, yeah, in that, no. Go back. Go back. The first one. Again, before that one. After that page. After the table that I've given you, yes. It's a newspaper clip there, but don't rely on the paper clip, the newspaper clip. The page after is a picture, then another page, and then you come to J2. It's marked J2 at the top there. My apologies, Mr. Marondeza, your bundle, it is in there, just continue. It's just jumbled up with the printer. I saw it there, J2, that one. And Judge, if I may have your attention for a second, in your bundle, if you go to the back of it, page 7 up, the last annexure is unfortunately and inadvertently in between annexure N. It should be annexure O at the end. Now, J2 says, and this is now Mr. Helgi Magnus Gunnarsson. Well, who is he? He's the Deputy Director of the Director of Public Prosecution in Iceland. He says, the state prosecutor in Namibia announced by a letter his intention to request the extradition of 3 Icelanders. We told him that we don't permit extradition, okay? All right, that's the upshot of that thing. So then on the following page, you can see there that they're talking about that issue. You see, Judge, why we need the documentation they would have sent for extradition if you want to see how it can assist us in our case, because quota was monetized. And one of the allegations they make with the assistance of a lady from Deloitte, her name is Melanie Harrison, is that she comes up with formulas of how quota is priced. We need the documents to show that there was no theft, there was no fraud, because those documents they would have sent and the information they would have sent would have either been proper information or curated. Because remember what I told you, and I'll show you, that the ACC was being used. Then I go to the next document, which is by Miss Ellen Sandra Skuladottir. Skuladottir says, you know, Erna and I were big chummies. We send each other emails. This is Dolly, this is what I mean. They send each other emails, they get documents. It doesn't work like that. There's a procedure. That is why in the International Cooperation in Criminal Matters Act, the executive director of the Ministry of Justice is called an accountable authority. There is a procedure that must be followed. You can't just call. We met at the judges' conference, stuur my ho. No, doesn't work like that. There are procedures. I want to take you, why is that necessary? To page 2 of that document. He says, let me start at paragraph 5. Based on the mutual legal assistance, one uploaded the emails listed in Annex 1 for the attention of the Anti-Corruption Commission of Namibia via the link, that one. I uploaded the emails on 2021, March 24. Emails marked in green were received by Gudanson and Detective Chief Inspector Gunstein, etc., employees of the Office of the DC, District Prosecutor of Iceland, from Finnbogi Reinson, Head of IST at Samherji. But those in yellow were received from the Office of the District Prosecutor of Iceland from Central Bank of Iceland. The Office of the District Prosecutor of Iceland stores emails in clear e-discovery platform, and the emails uploaded and sent to the anti-corruption were extracted from this platform. Paragraph 6, she goes on to say that there's another now server here that is listed here, and then you require translated signatures. Then in paragraph 8, he says the original copies of the translated emails are attached, and then they were couriered to, they were sent them by courier to Vandermeer. You see, Judge, what was happening here is that the document gets changed from its original form to another form. Because, why am I saying this? Mr. Marondeze will be honest to tell you that it was shown in the bail proceedings of at least accused 1 and 5. No, just wait for it. That there were emails that didn't have a name of who sent them. Or there were emails that don't have the name of who's the recipient. The email-wise, it's blank. That is the case. We want to check and look at the integrity so we may challenge the evidence. Will I have a fair trial if I'm not allowed? Can electronic evidence be manipulated? Yes or no? Judge, I won't answer that question for you. I hold you in high regard. I will not answer that question for you. I've already talked about the document that is B, C, D, and E. Now I want to take you to F in the replying affidavit. It's from Okakrim. Okakrim is from Sweden. Norway, sorry. The Norwegian National Authority for Investigation and Prosecution of Economic and Environmental Crime. The document is dated in 2020. It talks of folders and formats here. On page 2, you will see there's a reference to paragraph 3, transferred to Tundavala Invest. Now that name appears in the summary of substantial facts in the charge sheet. So we know now where the information is coming from. Now, this particular document was not disclosed by the state. We found it through a disclosure made in the POCA application.
Are you referring now specifically to
F1.
this document?
Yes, Judge. This F1. And there are many. And Deloitte relies on the information for Norway. They say so. I'll take you there. I'm now showing you the relevance, why we are asking for these documents. It's not being disclosed, but it's being disclosed there. They're keeping information away. They're playing the game. In that document, the next document, F2, is an affidavit. I don't know how they do it in Norway, but if this is an affidavit, again, it's another Sis Dolly letter. But on the last page of it, under the box image there's a paragraph. Excel files are bank statements. Following a conversation with advocate E.L. van der Merwe in Namibia, it was one Excel, etc. I can't read it. Had the password on, I gave her the password. You see, can an Excel document be manipulated? I won't answer that question. Even IQ of 80 can answer that question. They can be. And then, let's look at the date of that document. First of all, with reference to the previous document, that previous document, F1, was done, as I told you, 29 April 2020. And in that document, there's reference to the persons who handled this information. On the last page, it is marked, it's now coming from that disclosure, as 1749. You will find there it's written that Special Investigator Elizabeth Meyer, telephone number, who are the lead investigator on the case. All right? Together with Joachim Ziesler. Now, this F2 document was done only, that's April. This is in August 2020. The evidence is assembled then. The affidavit comes later. It's already dispatched to Namibia. Now she's talking about, and then there were two requests made, because in there, there's reference to your letter dated 6 December 2019 and 12 February 2020. Why those requests are needed and why the information received in those two requests are needed is again for us to check what manipulation was happening, how is that relevant to the charges we have, because as I told you, Tundavala comes from there. Let's now go to G. G is dated 14 October 2019. It's done by the Inspector General of Police, and it is authority to act under 83 of the POCA, Prevention of Organized Crime Act. So once they would have acted, they would have produced a report. Where is the report? So that is why we need it. You cannot have access to the police docket. That is what the PG says. Let me take you to document G1. It is by Petros Kangameni. And attached to Mr. Kangameni's affidavit, if you find pages like this, Judge, then you are at the right place. Handwritten, scribbled notes from his pocket handbook. Nothing says an investigation diary more than a police pocketbook where he makes inscriptions. You've disclosed part of them, just disclose everything. Why are you disclosing some and not disclosing all? Then document age. Deloitte. I want to take you to certain paragraphs, Judge, if you don't mind. This was done on 9 June 2021. This is well after charges have been merged but it's clear that the charges were based on Deloitte. Language alone, it doesn't hide. Even with Mr. Marondese's high English from the Shona Highlands, that one is from Deloitte. You can almost cut and paste some of the language, I tell you. From the charge sheet to Deloitte. Now, that letter says on its cover page, where records were not available in the ACC investigation case files or not received or obtained from third parties as requested by the ACC, we were not able to make factual findings regarding the aspects relating to those documents. In the circumstances where we could not find the relevant corroboration for evidence, you should not rely on our work and our report as being comprehensive, as we may not have become aware of all facts of information that you may regard as relevant. If you page over, he says, we therefore did not have the opportunity to obtain the versions of the persons of interest to take into consideration before making our findings, as there were no consultations with the interested parties in the matters. This report may not reflect full information of all relevant documentation and transactions or the identified documentations and transactions reported therefore. You see, I was referring you to Article 94 when you asked me a question. 94.1, sub 3. The Anti-Corruption Commission shall be an independent and impartial body. It's also repeated in their act, but once we have a constitution, we stick with the constitution. Now, you continue further in that document, paragraph 1.5. This is now why I'm asking for the correspondences that happened between the ACC and Deloitte after the concurrence of 5 March was given by the Prime Minister. According to the terms of reference that form part of our document, the scope of our services was to include 1.5.1, conduct a forensic audit. Then you page over, 1.6. Following our appointment, we met with the ACC inter alia to obtain clarity regarding the scope of the Deloitte investigation and to agree on the priority scope items referred to in the terms of reference. Based on our discussions with the ACC, we agreed our scope to focus on the following. So something changed. Something was given to them, then they met, then they changed. And then, paragraph 1.9, our work did not constitute a statutory audit under the International Financial Reporting Standards or the International Auditing Standards. We therefore do not express an audit opinion in accordance with the ISA, paragraph 1.11. So, with the greatest respect, this document, and I'm asking, the PG calls it an audit report. It's not even a forensic report. It's because forensic goes beyond audit. It's higher standard than auditing. This one says we didn't even meet the normal standards of reporting or accounting. So the PG mustn't call it an audit report. You must just call it a report. Then we go to the document I. This is an email between Samuel Nankela of the Ministry of Finance. This is how documents, items that were taken, seized, were then transported to South Africa. It tells you here, because Erna wanted the documents sent to South Africa. This has an impact on the chain of custody. We want to see what happened. SESRAI. It's a Gmail email. It appears that at the ACC they don't have official emails. There's ernavandermerwe1@gmail.com. If Trump was here, he would have been saying that private emails. Anyway. Then we go to SES-RAJ. Now we are getting into the thick of things. Just before that, those board meetings. Those board minutes, just before that. Go that side. That side. After the email. You see, Judge, we've been asking for a legible copy of the email of the affidavit of one Silvanus Thikameni Kathindi. You may ask, who is this individual? Silvanus Thikameni Kathindi is a former convict who has turned himself into a businessman, who was a businessman owning equity in something called Etale Fisheries, Etale Fishing, whatever, Etale. Etale had an association with NAMSO, but I will show you. You will find at the top there, do you see there where it says ACCHQO-14-001277, Judge? Do you see that? Okay. Now, that is when these issues were investigated. And it is dated, that document is dated 29 October 2014. Okay? Now, just looking at this document, Judge, I don't know, Mr. Marandez, it's the same, yes. You can't read it. It's not legible. I want to read it. It's relevant. Why do I say it's relevant? Because that number there, I'll come and show you now where it is. That number is everywhere. It's part of this investigation. So when Mr. Marandez says it was not part of the docket, it's not part of the investigation, what in the world is he talking about? This is the genesis. What does he complain about? He says, granting of a fishing right, paragraph 2, non-right holders, paragraph 3, fisheries agreements, paragraph 4, reduction of horse mackerel quotas to right holders, paragraph 5, term of fishing right. You see, what had happened was, in 2011, and this is, I've referred you to the case of the University of Namibia. Context is everything. That's what the Supreme Court says. Context is everything. In 2011, Bernardt Esau issued rights to many Namibians. They don't have vessels because we're a rights-based fishery, not an effort-based fishery. I know I'm speaking Latin, but just hear me out. It attracted a lot of operators. They came. NAMSOV, which was a duopoly with Erongo, became threatened. They lost businesses. They lost their capacity to print the money they were printing. What did they do? They went on the lobby. They wanted to get that right, those rights. They called them theirs. Law Reform held a workshop in 2012. And we explained to them, but it's not your right to a quota. You have a right and you can be given quota per application. You don't have a right to a certain amount of a quota. They took affront to it. They went to court. A judgment was delivered by Justice Mwatelulo. After they failed that, they then decided to criminalize it. Using who? The ACC. But don't believe, I'm coming there. Look at the affidavit that follows the document K. This affidavit was done by Ndeshipanda Kanyangela seeking our arrest. It is dated 26 November 2019, the day before elections. I'm arrested on election day. Okay, in that affidavit, please go to paragraph 4. He says this investigation was prompted in 2014 by allegations contained in a newspaper article in the Namibian newspaper, and during this year by information from a whistleblower. So we now know that there's newspaper articles, and it started in 2014. Now let me show you those newspaper articles. The next document, well, first, before we get there, remember I told you about how NAMSOV was talking about the quotas, etc. Document SESRA is a document of Trachurus Fishing Proprietary Limited. Minutes of a board meeting chaired by Sebulon Kankondi, Arends, Jan Arnold, Gauseb, Hugh, Mouton, Naholo, Paulsmeyer, Weitz. Bastos, the same one I saw in the newspaper recently, this one, he was not there. Now, no, this is what the document says. Then, in that document, on page 2 of that document, you just page over, quota, there's a title called quota. You read somewhere there, they say, upon inquiry from management, the MFR provided no reason for this reduction and advised that we should acquire the shortfall from the new beneficiaries. These are the new right holders now. After high-level lobbying and involvement of legal counsel, Mr. Koop, etc., then they go at the bottom there. Of particular concern was the allocation of horse mackerel quotas to non-horse mackerel right holders, and this is at the expense of the invested members of the horse mackerel industry, such as Trahurus. Now, Trahurus is a subsidiary of NAMSOV. I can invite anybody to oppose that to give evidence otherwise. But remember, I'm telling you the context, that they needed this quota. They were getting it from other people. Now, on the next page, the third paragraph from up top, SG suggested that SG, if you look at the legend there, that is how said, that they should go to the president, the prime minister, with the facts and figures, talking about it. Quiseb and Gendev said they won't do any legal action. Okay? You page over, and then, well, it's not really necessary anymore. I was trying to look for, those are other minutes. We've been given a bundle of these, and I'll tell you exactly when we got them. But again, they're not complete. There are certain minutes where they then decided now to, after the legal action fails. The newspapers start at M1. M1, up there is Oshiri Nashipopiwe. On that page of Oshiri Nashipopiwe, you will find there allocation list versus quota. Look here, Mr. Marandezi, if you can, yeah, the one where your hand is. Allocation list versus quotas. In there you will find now Etale Fishing Company. You see? Etale is complaining there that apparently they had to close. Okay. Etale, the same one that Kathindi, who's related to the Attorney General, Kathindi, is the one of Etale there. Now you go to the Namibia newspaper. Wednesday, 17 September 2014. This is what Kanyangela said. Kanyangela said it started with the newspaper. Here's the newspaper. Talks about, that's the context. Wait. Then you go to the next one. That's again September 2014. It's the Namibia newspaper article. Then you'll see one that looks like this, Judge, if I don't know if you can see this one. That's now NAMSOV, clarifies misconceptions. And then it says there that the people in there is Werner Hermann Schmidt, he was in those minutes. Tuna Vellum, she was not in those minutes. Jan Arnold and Garden Hungua, who was not in those. These are the people now who are spearheading this whole Oshiri Nashipopiwe thing. And then you go to the document N, which is, I said, has been misplaced in your bundle. It is 7 pages from the bottom there. That document is a memorandum. Is a memorandum. And I've quoted for you in my head, and I just want to read for you paragraphs 1 to 3. What is set out below is intended to assist the Director of the Anti-Corruption Commission in coming to the conclusion that a variety of offenses under both the Anti-Corruption Act 8 of 2003 and the Marine Resources Act have been committed by the Honorable Minister of Fisheries marine resources, parties within the employment of the minister, and parties who have benefited under unlawful allocations of fishing quotas by the ministry. The assistance that we render as contemplated above is aimed at facilitating criminal charges against the parties set out in paragraphs 1.1 to 1.3. We place on record that in the event that no charges are brought against such parties, we shall consider pursuing a private prosecution against them. We also record that at this stage, the charges that we have formulated later below are in most cases based upon objective, unassailable evidence. However, there are also some instances of charges that have to be further investigated, in respect of which the prosecuting authorities of Namibia and the Namibian police are better equipped to conduct such investigation. Where we refer to such latter charges, we shall identify such charge with an asterisk. And then that document, you will see, Judge, that this should be the first page. It doesn't say what it was attached to. We don't know when it was generated, but surely it tells you that the case has already been rendered in December of 2014 by Justice Mwatelulo. He hasn't set aside the allocations, and then they now start. Then you go to page 3. Then you go to page 5. Maybe it's just but it's incomplete. Why are you giving me something that is incomplete? I need something that is complete. And remember what I said about Article 94. The ACC shall be independent and impartial. Apparently they were not. Then you now go to the last document, O. This is a note done by, it says N. Becker. It can only be the one and only Commissioner Nelius Becker. Director General, these are the 2 cases regarding the Minister of Fisheries. The matter has been adjudicated in court in favor of the plaintiffs. Should I request copies of the documentation handed in the civil case, and should we pursue the matter criminally? See, so when they lost now civilly, they were now moving to, and it starts there with NAMSOF. That is the context. Just now give us everything, so we can be able to check whether or not you acted in accordance with your legislation. Then, that's 24 December 2014. Then there it says, please proceed and obtain the documents from the PS. Obtain statements from potential witnesses. That signature looks like the signature of Paulus Noah. That's the context. Now, Judge, actually, we've made out a case to be provided with the docket, even though this was not an application for the police docket. Later on, I discovered, but hey, we've actually complied with all the requirements. We've actually made out a case. And then I give you the case of Vander Westhuizen in 2018. He says that the learned judge states that you must show, the court must decide, A, whether the accused needs the information to answer the charge. And we're saying, yes, we do. I've shown you. B, whether the refusal to give the particulars will be prejudicial to the accused. And we're saying they will be. C,
my apologies.
I'm at page 28.
Yes, I know. Is there a citation of the Van der Westhuizen case?
Yes, Judge. It is on page 27 in footnote 40.
Thank you.
Sorry, it's Van der Westhuizen. So,
May I proceed?
and then, what is the relevance of the particulars requested after plea? I've shown you the relevance. Before the evidence has been led. This is the case. Does the interest of justice dictate that they be provided? We say they do. I've given you the case of R.V. Ward. I've given you the case of R.V. Lesson. I've given you Shabalala. I've given you Stinchcomb. I've given you multiple authorities to show that. And then I've factually gone to show you why we need the evidence. The state hasn't given you any evidence. They just say we're not entitled to it, without more. They don't claim any immunity or privilege. They just say you're not entitled to it. They just say prejudice. But I've given you, and I'll read it to you again, what was said by the judge there. We now know that Shabalala says that the docket contains 3 sections. Witness statements taken by the investigation officer, B, internal reports and memoranda, and the investigation diary. We've been provided all of this in bits and pieces, drips and drops. Why are you just not giving everything to us? So, Section A has been availed with the exception of what we request. And we request in J there, the document I had shown you, J, that is the Inspector General's, the letter, the affidavit of Silvanus Fikameni Kathindi. Section B has been sporadically given to us, and I refer you to, in the founding affidavit, to the document 3, the so-called referrals. And then section C, I refer you to those documents marked G, G1, where you have the diary of. Now, I go to the issue of where we get these documents. I've done a table for you, Judge. I want to give the state a copy as well so they can look at the table. What you have there, Judge, is an indication where I got these documents. SESRA, that's the first document we got from the POCA files relating to that issue that has now been resolved between the PG and the Icelanders. The documents SESRA to E we got from the disclosure of the Namgoma docket in June 1, 2023. Then SESRA F1 and F2 we got from the POCA itself. Then SESRA G, the state disclosed during a bail during 2020. My bad. And then G1, the Namgoma disclosure made 22 April 2021. Then Age was disclosure made in the Fishco matter, which because they are merged, on 22 April 2021. Then files I, J, and K and L were disclosed separately, but in Namgoma, some in 22 April 2021, some in 1 June 2023. Then comes now the post-Valentine disclosure, M1 to O, file 1. Now, and by the way, Judge, as I said, none of these things are paginated. So it's really a nightmare going through just to assemble what I've given you here. Okay, now, why I've given you that is to show you just how piecemeal the disclosure is, how sporadic it's been, and how disjointed it is. I've put to, oh yes, I need to show you, sorry, if I may take you back to the document in the founding affidavit 3. At that document, at the end of that document, you have the Prime Minister's letter. Well, ACC letter sent to the Prime Minister. It's disclosed. In that it looks like this. Okay. Up there, the reference is ACC ERO-14-001270. ACC HQO-14-001277, ACC-HQO-14-001080, ACC-HQO-15-001556. When they get permission for Deloitte, they say that these are the investigation references that they have. It is therefore relevant to me. I've shown you where those affidavits, even the affidavit of Mr. Kanyangela, in the replying affidavit, I've made a copy and attached it. It is the document, I believe, marked K, SESRAK. It starts up there, ACC ERO-14-001270. If you give us now the information that was sent to these countries, we'll be able to see if, because it means that this is the investigation that started in 2014. Everything is relevant. And in law, context is everything. What's the purpose of getting 1,900 pages from Angola and translating 200 for me? And by the way, we can read Portuguese, some of us. We'd like to see whether this translation is correct. Je remember. So that is the context. Now, I want to end off, Judge, by giving you, I've provided you a copy of the Convention Against Corruption and the Convention Against Transorganized National Crime.
It's not necessary, I do have them.
You have a copy? All right. I want to refer you to specific parts. Let's start with the Convention on Transorganized National Crime. On page 35 of the Convention, Article 34. Implementation of the Convention. What is important in that paragraph is, when they implement, it must be done in accordance with the fundamental principles of its domestic law. And the domestic law's fundamental principle is reciprocity. I know that they will tell you to refer to Article 18 of the Convention on page 19. But 19.2 says, mutual legal assistance shall be afforded to the fullest extent possible under relevant laws. Treaties, agreements, and arrangements for the requested state party with respect to investigations, etc. We now know that 30 of the International Cooperation in Criminal Matters Act applies to arrangements that existed. After the law came into being, you had to have an agreement. You can't bypass the law. It's this, and I said to it, it says 38 times, it says it subsidiarizes itself to the national law. And we know what the national law says. The Constitution is supreme. It says Parliament is the primary principal legislative body of Namibia. It makes the laws. And that law is the International Cooperation in Criminal Matters Act. The Convention only applies to the extent in terms of 144 that it's not in conflict with that legislation. 27 says there must be an agreement. Now, why is the information for the referral needed, whether it's the police or the ACC? It's because we need to see, had the Director General or the Inspector General actually done their work and exercised their mind as they're required to under those sections, whether it's 83 or 31, and nobody else can do it, just them. It's not delegable. It would have been obvious to them that maybe the evidence we obtained unlawfully, and then maybe certain charges wouldn't be preferred. I'm entitled to challenge that. That's what Scholz says to you. That's what Scholz says to all and sunder. It says, and I refer you again to where it says that in Shabalala, actually not, what a fair trial might require, and I'm on page 12 of my head, in a particular case depends on the circumstances, the simplicity of the case, either on law or in the facts of both. This is not a simple case. I've shown you how even the Prosecutor General doesn't apparently understand, and I don't blame her, it's not her function. She should get advice from the Attorney General. But she could listen to mine, I was also an Attorney General. She's not entitled to rely on international instruments without more. The special circumstances of this case is that if we don't get the substantial number of documents which we've listed, we will have problems. I know that they want to rely on Article 18, but of that convention. It subsidiarizes itself to the national law. We are not a monist country without more. We are a weak monist or a qualified. In fact, the UN says we're a dualist country. Even Angola, where we have a treaty, even Angola, which is listed in the schedule, you still go through the procedure. What more if there's no legislation, no treaty, which has been ratified by the parliament and negotiated under 32 with the permission of the president? The sovereignty of our country will undermine it. And I've given you cases, Judge. In a case, I've given you a case, actually, I hope attached to the schedule of the cases. It's the case of if I'm not mistaken, it's Custodina versus the Ministry of Home Affairs, 2022. I refer to it on page, my apologies, Dad, let me just get there. Page 22, footnote 27. You can't just, it says you have to consider the sovereignty of our country. Related to Home Affairs, immigration, where people were just saying in the convention, like, no, the court said, no. Paragraph 21 of that judgment says, no. Namibia is a sovereign country. You have to be careful. So, all this information that we request, I've shown you now what was disclosed, when it was disclosed. I've shown you why I need all this that I'm requiring, what my rights are with reference to case law. I've shown you how they've misinterpreted the convention. And I've shown you that we've actually complied. It's as if we were making a request for the police docket to be available. Having said that, Judge, unless you have any specific question, I will wait to reply to whatever Mr. Marondeze would like to answer. And considering the time, is it opportune perhaps to have just a health break?
Yes, Mr. Marondeze, am I correct in saying it's about 12 o'clock?
Yes, my lord, my lady.
Shall we reconvene at 2? That would give you 2 hours, you and your colleague.
Oh, we actually don't need those 2 hours, my lady. We wanted to proceed now. We just wanted to ask for a health break, then we proceed.
Then we can reconvene at 12:15.
Is the court please?
Court adjourns.
Excuse, I think I follow what this application is about, and as it's on the electronic platform, I will familiarize myself with the exchanged pleadings And when the ruling is made, my lady, I'll consider that and see how it impacts my client. But may I
No
also
problem.
be
Mr. McNally, you have a similar request?
Indeed, my lady.
You are
My
then
lady.
excused.
Thank you for your time. I appreciate it.
Mr. Bernardt.
Yes, the court, please, my lady. Again, we apologize, my lady, for not having filed days of arguments. It's because we're involved in another matter, a long-running matter. When the answering affidavit was filed on Monday, we couldn't get sufficient time to file days of arguments, my lady. But after having listened to the applicants, the state is in a position to address the court on the issues raised, my lady. And we will be relying on the answering affidavit, which was filed off record, my lady. My lady, this is the first case I have been able to sit in where an applicant solely relies on the replying affidavit instead of the founding affidavit. My lady, that's the purpose that applicant should stand or fall on the founding affidavit. Because the purpose of the answering affidavit, of the replying affidavit, my lady, is just should be confined to matters or explanation not previously addressed, which have been raised in the answering affidavit. The applicant should not be allowed to raise new issues which have not been dealt with in the founding affidavit, as has been done in this matter. So I'll show the Honorable Court the new issues which have been introduced in the replying affidavit, which the respondents did not have time to deal with in the answering affidavit. My lady, the applicant, which are listed in their notes of motion, and they're seeking specific orders and specific documents to be released to them by the state. My lady, I'll refer this Honorable Court to the notice of motion which was filed by the second, third, and sixth accused persons on the 5th of June 2025. The documents which they are seeking are listed from paragraph 1 of the notice of motion up to paragraph 9.
Just a moment. Which document are you referring to, Mr.
It's a notice of motion which is dated 5 June 2025, which has signatures which appear to be one for the first applicant, Mr. Shanghala, and the other one is the long one. It must be Mr. Hatuikulipi James, and the other scribbled one must be for Mr. Pius Mwatelulo. It's not. If you look at those documents, my lady, which were filed, I will read for the purpose of the record. The Section 14 of the Anti-Corruption Act 2003, Act number 8 of 2023, concurrence by the Prime Minister for the appointment of delay to in touch to conduct an investigation. That point is mute now, because by the time this application was filed, all the accused persons, including those who are not involved in this matter, had been served with that concurrence letter and the application by the Anti-Corruption Act, by Anti-Corruption Commission. Then the other documents which are required in paragraph 2 is the bilateral agreements envisaged under the International Cooperation in Criminal Matters Act 2000, Act 9 of 2000 between the Republic of Namibia and the following countries: Iceland, Norway, United Arab Emirates. My lady, this has been dealt with in the answering affidavit, but surprisingly today, an additional country was added in the arguments, which is not mentioned in the case which the respondents were made to come and face in this court. Angola was added, but it's not part of the order they were seeking. Other documents in paragraph 3, mutual legal assistance, ML, a request transmitted the competent authorities by the Republic of Namibia to any of the above countries, as well as any countries listed in schedule to the International Cooperation in Criminal Matters Act, from which any evidence disclosed in this case was obtained. Responses of paragraph 4, those are the, but I don't need to go through all those things, my lady, because they're already there. Those are the matters which were being sought by the applicants to be released to them. My lady, today we are faced with a replying affidavit, which is 5 times thicker than the original application, and which has several other matters which are not being requested for in the notice of motion. That should not be allowed, my lady. They should know what they want. They should put their house in order. They should know what they want and request for what they want. And we deal with the things they requested, not to come and meet a mirage or a barrage of other requests or demands which were not sought in the notice of motion. My lady, having said that, I would hasten to deal with the addresses with regards to the documents which have been requested. If my lady, take into account the address by the Mr. Shanghala, the first applicant, as to the nature of the documents they wanted, and the cases which he relied with, Schultz and other cases, Shabalala and other cases which he relied on, my lady. If those were the earliest cases when the issue of the disclosure of the police docket became relevant, my lady. All the cases. And those cases, they deal with the disclosure of witness statements and any other material which is in the docket. They don't deal with the documents which have been requested by the applicants. They don't do that nature of the documents. So it's surprising that they were being relied upon by the applicants. One of them, who boasts to be the former Attorney General and former Minister of Justice, he should have known better that they don't assist him in what he's seeking for. My lord, my lady, those cases, and because he has relied on the answering affidavit, he has not dealt with the tenor and thrust of the answering affidavit. The answering affidavit has said the documents which he seeks to be released to him form part of the investigation diary, which he seeks to relate to in his notice of motion. He has not provided this honorable court with a single case which deals with the investigation diary. But all the cases he has provided this honorable court, you have to do with witness statements and evidence which is of which is of no use to the state, but which might be necessary and relevant to the accused persons. Those are the cases he has cited. He has not dealt with the cases which actually deal with the investigation diary. I'll get to address this honorable court to that in due case, but I think we'll better start with a shorter and a simple matter, my lady. That of the we issue that the Prosecutor General spoke about that there are no bilateral agreements between those countries, those specific countries which are mentioned in the notice of motion, my lady. My lady, the International Cooperation in Criminal Matters Act number 9 of 2000, in particular section 30, is very clear. And for the record, I will read it in the record. It says, it provides as follows: nothing in this act contained shall be construed as to prevent, underline the word prevent, or abrogate, or derogate from any arrangement or practice for the provision or obtaining of international cooperation in criminal matters otherwise than in the manner provided in this act. He has described this part with the meaning of abrogate. I agree with him with the meaning of abrogate. That's repealing on any laws. But he deliberately avoided addressing this honorable court on the word prevent. There's nothing that will prevent the collection of evidence other than in terms of what is provided for in that section, my lady. So it's shocking for a former Attorney General to allege that what has been done is illegal and is not in accordance with the laws of this honorable country. When there's the law which was in existence at the time he was Attorney General and was Minister of Justice, this legislation was in place. You should have known better the provisions of this legislation, my lady. So it's not illegal for the state and the Anti-Corruption Commission or the investigators to have collected the information they did in terms of the international conventions which I mentioned in the answering affidavit, my lady. And Section 30, my lady, should be read in conjunction with Article 18 of the United Nations Conventions Against Transorganized Crime. Article 18 provides that member states and parties to this convention, which is not disputing that Namibia is a party to this convention, and those countries which he has referred in his answering in his notice of motion, my lady, he has not denied that those countries are parties to this convention. He's not denying that. They're not denying that. Article 18 provides that state parties shall afford one another the widest measure of mutual legal assistance. That's subsection 1. In investigations, prosecution, and judicial proceedings in relation to the offenses covered in this convention. And these offenses he is facing today, they are also covered in this convention. He's not disputing that. And the Article 18 is very clear. They should afford each other. And subsection, I will not read the whole of subsection 1. I'll go to subsection 2, my lady. It provides that mutual legal assistance shall be afforded to the fullest extent possible under relevant laws. That is where he was limiting his reading, my lady. But the subsection 2 goes further and says treaties, agreements, arrangements of the requested party and with respect to investigations prosecution. It is not only limited to the laws, because he wanted just to limit that this was not done in terms of the international criminal cooperation in criminal matters, so it was not done. But no. It also covers that laws, treaties, and agreements and arrangements that are covered. It should not only be in terms of the international cooperation in criminal matters, my lady. That was a deliberate misreading of the act on his party to suit his needs, my lady. So, my lady, it's the state's submission that, as provided for in the answering affidavit, the evidence was collected in terms of the allowed statutes and international conventions, and there's nothing amiss about that. Now, my lady, we go to, is he entitled to that evidence which was lawfully is it entitled to the documents as per his notice of motion? Of course, he's entitled to the evidence collected, and that has been given to all the accused persons. The evidence has been collected, and they are entitled to that evidence. That evidence has been provided to them. And he is not saying he has not been provided. What he wants is, he wants to see, I want to see the emails which you were exchanging. I want to see the actual request which was sent. That is prohibited by Section 2A of the International Cooperation in Criminal Matters, my lady. Section 2A reads as follows. Non-disclosure of requests for assistance. Unless otherwise authorized by law, a person who became in his or her official capacity or office became aware of the request for assistance there is knowledge of the contents of the request for assistance made under this act, the effect that the request for assistance has been or is about to be made, or the fact that the request for assistance has been made, has been granted or refused, shall not disclose the contents or effects of such request except to the extent that the disclosure is necessary to execute the request for assistance from a foreign state. There's only one condition which these requests for microeconomic assistance can be disclosed. If they are going to be necessary to execute the request for assistance from a foreign state, that's the only way they can be disclosed, my lady. It is not their case that these applicants in this court, honorable court, they are foreign states. They are accused persons in this case. They're not foreign states, and they don't want to execute any of these requests. That's the purpose for all they can be requested, my lady. Not for the purpose for which they seek them to be released to them. Therefore, my lady, that request for those documents is misplaced and is based on a misunderstanding of the law. My lady, he has referred in his addresses to documents attached to his answering affidavit, Exhibit G, that yes, they've requested release part of this. No, those documents are part of the docket, and they've been released to them because they don't form part of the request, but they were documents which were requested in terms of a letter of request, which Section 6 of the Act, my lady, provides that where a letter of request issued after proceedings have been instituted, the evidence so obtained together with the record of proceedings in the examination of witness shall be open for inspection by the parties of the proceedings. Those documents which he is referring to were requested from Angola after this case had already been transferred to this honorable court in the High Court. And those documents, witnesses were interviewed by the magistrates in that country, and they gave their evidence, and that is the evidence which was disclosed to them. Lawfully so, because the law provides for that they should have everything. He is not telling the court the truth when he says those are where the requests. No, this was done upon letter of request, and that is what was disclosed to them. That should not be open the doors for them to get the other requests which are prohibited under Section 2A of the Act. And he has not provided any such documents, my lady, that we have requested any such documents which are prohibited by Section 2A of the Act. And therefore, my lady, it's our submission that those documents, they are not entitled to them. My lady, we also note that when he was addressing this honorable court, he referred to a myriad of cases from outside this jurisdiction. There's a directive already from the High Court and Supreme Court that if a party cites a case from outside this jurisdiction, you must deposit a certificate to say, after due diligence and the spirited research, you could not find any case law authority in this country dealing with that particular point. That has not been done. He has not done that. And he has cited this honorable court. Are those cases, what value of those cases to this honorable court? Are they persuasive? Are they binding? But certainly they are not binding. He has cited English cases, Canadian cases, Japanese cases. If those cases have been referred to in this jurisdiction, my lady, they have not. And he cannot provide any case where these cases have been referred to in this jurisdiction. So why bother the court by setting such authority? We have good authorities in this case, madam. We have good jurisprudence in this case, in this court, in this country, dealing with the same principles which are dealing with here today. He ignored that jurisprudence. My lady, we have a good case. Case court authority in this case, in this country, will make a copy available to the court, which is not written at the back, is the matter of Matthias Schweder versus the state, the Prosecutor General, the Inspector General of Republic of Police, Paulus Kapia, Ines Gassis, Otneel Shuudifonya, Sharon Lynette Blau, Ralph Patrick Blau, and Nicholas Cornelius Josiah. This is popularly known as the Avid case. It's High Court case number CC27 of 2008.
Just repeat, 16.
Pardon, my lord?
Just repeat the citation.
CC27 of 2008. It's difficult to find this judgment, my lady, but I'm lucky because I was the prosecutor in that matter of the Avid case. That's why I have this judgment. Mm-hmm. That is the judgment where the accused person, Matthias Schweder, demanded for a police investigation diary. On speculative grounds like what has been done in this honorable court, we might find something that will assist us. We might find that something was unlawfully done. We might find that something was not done according to the law. Speculation. It's not allowed in law, my lady. You must come up with cogent facts. That's what Schweder says, the judgment of Schweder is when you request for in fact, this case of Master Schweder, it discussed the matter of State versus Scholz, which the first applicant and his colleagues relied on. And it says that Scholz did not deal with the issue of the investigation diary. Party C and B and C. Yes, it says it did not deal with, Scholz did not deal with the investigation diary. Scholz dealt with evidential material in the docket, whether or not the state is going to rely on that evidential material should be made available to the accused, not the investigation diary. My lady, the judgment I'm referring to, it says that you can't just come and say, I will not have a fair trial in terms of Article 12 of the Constitution because the investigation diary has not been disclosed to me, or I will not be able to prepare for my defense because the investigation diary has been. The case is, for you to be able to justify yourself to get the investigation diary, you must provide cogent and strong evidence and facts to show that this is how the investigation diary is going to assist you in the preparation of your defense. And you don't come up with speculation that it might or might not what. And this court, the court in this case of Shiweda says that the investigation diary is excluded from disclosure to the accused persons. And the state is not required at all in terms of whether there's a case that we need to show that the disclosure of the investigation diary might impede the ends of justice or it is against public interest. No, we don't need to do that, my lord, in terms of state matters whether versus the state. My lord, I suspect that the applicants had sight of this judgment. That's why then they avoided and they never talked about the investigation diary anymore in their submissions, my lady. And the Prosecutor General has made it clear it's one of the issues she brought to the fore in the answering affidavit, that the documents otherwise they are requesting for, they are part of the investigation. Also, if you look at Section 2A, and that they are part of the investigation diary, my lady. My lady, it should also be shown that some of the cases which he relied upon, the South African cases, and those cases applications were made to court based on the provisions of the South African Constitution. And those provisions of the South African Constitutions are absent in our Constitution, for which some of those cases he addressed this honorable court on. They are not there, and therefore they cannot be allowed, my lady. We agree that Namibia is a sovereign state, and Namibia is the constitution of this country is the supreme law of the country. That's why we are saying, we being a sovereign state, we must rely on our jurisprudence. You must not try and import jurisprudence from other countries which has never been relied to in this country. And we appreciate his industry, my lady, because at one stage he even gave the number of times words okay in a particular convention. He counted, I'm moving to number 38 times. I appreciate his industry, but that industry was misplaced. My lady, he is demanding that the Prosecutor General should have brought a legal opinion from the Attorney General. it's a bizarre suggestion and it's a weird one, given that him being a former Attorney General of this country should have known about the case of Attorney General versus the Prosecutor General, which governs the relationship between the Prosecutor General and the Attorney General. The Prosecutor General is solely responsible for the prosecution of cases in the name of the state in terms of the constitution in this country, not the Attorney General. There's no need to seek opinion from the Attorney General on criminal matters, my lady. As per that case. It's a popular case, my lady. I just don't have the suggestion, but it's a popular case in Attorney General versus the Prosecutor General, which governs the relationship. We don't need an legal opinion on how to prosecute. We are fully equipped and with the expertise required to handle the mandate imposed upon the Office of the Prosecutor General by the Constitution, my lady. Lady, if I can just say the citation of that case is ex parte Attorney General in reconstitutional relationship between Attorney General and the Prosecutor General, Supreme Court of Namibia, number 7, 1993, brackets 1995, Namibia, the Supreme Court delivered on 13 July 1995.
Thank you.
As the court, please, my lady, I heard some argument that that disclosure of the communication and the whatever will enable the lower courts to review the decision of the Prosecutor General, whether it was done lawfully or in terms of the law, it requires judicial overseeing. My lady, I might be mistaken, but I'm not mistaken. The district courts have no review powers. The review powers are the High Court and the Supreme Court. I don't know why he wants the district courts to have review power. He should have amended the laws when he was in the office, my lady, to close those courts with those powers of review. He did not do that. So it can now, because he's giving this case, that he have those cases, my lady. My lady, if you look at the documents, my lady, which are in the answering affidavit, we are not agreeing that they are properly before this court, because he was supposed to attach them to his founding affidavit. And those documents, he cannot at all say that they became necessary because of the response by the state in its answering affidavit. My lady, if you look at SESRA J2O of the answering affidavit, those documents are not even mentioned in his notice of motion. They're not mentioned, and they don't form part of the notice of motion. However, I would like to bring this attention to the Honorable Court that those documents were already disclosed to the accused persons by the state. Upon the request of the accused persons. These documents don't form part of the docket, don't form part of the case which the state needs to prove against the accused persons, which the evidence which the state is going to rely on the prosecution of the accused persons. However, the accused persons said, it's not all of the accused persons, it's the current applicant who said, I need, because he's aware, He is aware that there was such an investigation which happened some time ago. He says, I want those documents. I want that docket. The state says, okay, even if we are not going to rely it on that document, on prosecuting you, we'll provide you with that document. That docket was provided. It's a huge docket, my lady. But he only chose to pick up a few documents from those dockets. But it's a huge docket. It was disclosed to him and all the other accused persons. But critically, those documents don't form part of his request in terms of the so-called request in terms of Section 7, which we say it doesn't comply, but nonetheless, we are saying to finalize this matter, we can argue on it. Those documents were disclosed, but they don't form part of the document, and they're not part of the documents which has been requested by the accused persons. Honestly, he is complaining that one of the documents is not legible. Really, is that a complaint which should be brought to this honorable court, my lady? That is, this document is not. Why didn't he say, Marondeze, that document is not, can I have a copy? I was going to give him a legible copy. He didn't do that. Now he's coming to burden this court with really a trivial request like that. My lady, but the bottom point is that those are documents which one, they're not part of the notice of motion, and two, they've already been disclosed, and they are not part of the documents on which the state is going to rely on in prosecuting the accused persons. If you look at Shiweda versus the state, the Prosecutor General and the Inspector General, that authority is clear. It says the contents of the docket on which the state is going to rely on the prosecution of the accused person. Not any other documents which are not part of that. My lady, we insist that the state cannot be compelled to do an investigation on behalf of an accused person so that he can see whether he can raise a defense from that information which is speculative. My lady, if you look at the Annex SESRA-A, which is the part of the answering affidavit, this information is not part of the police docket, especially the one which is written in J1. It's not part of the police docket which the state needs required to prosecute the accused person. And it said it's a request for, but for the record purpose and officially, Namibia has not yet forwarded a request for extradition to Iceland. The application is still being prepared. It has not. And also, my lady, if you look at the notice of motion which has been filed by the applicants in this matter, there's no reference to the Extradition Act or extradition documents requested there. They come up, they surface in the answering in the replying affidavit. They're not part of the order which is being sought by the applicants. There's a document, affidavit, which was read also in the record, I think is SERA, which refers to emails, my lady. Yes, which is S-E-R-A, then A in brackets. That affidavit, my lady, is not communication in terms of the request. This is actual evidence which was received from Iceland, to which the emails were attached. And those emails and this affidavit, together with this affidavit, and this person will be coming to testify in this honorable court, have already been disclosed to the accused persons. The evidence, we are not disputing that it's entitled to the evidence. The evidence has been disclosed, which was obtained in terms of those mutual requests for legal assistance. This is part of the evidence which was disclosed by the state to the accused person, together with emails. My Lord, there's reference that some of the documents, they go them through the POC application, but the POC application is not the docket against the accused persons. Some of the matters they are fighting there, the state, because these matters were raised in the answering affidavit, in the replying affidavit, they could not be dealt with by we could have requested the requisite department who deals with POCA to comment on their comment and how they disclose such document to the accused persons. My lady, there's been a lot of mentioning that we want to see whether there was a manipulation of the evidence. We want to see whether the state has manipulated the evidence, whether they've done anything. And he says that Mr. Marozi can be witness. I refuse to be his witness anyway, but I cannot be his witness. But there's no manipulation. That's what is clearly prohibited by the matter of Matthias Chiweda versus the state, that we don't talk of speculation, my lord. We don't act on speculative drive. He was on a high speculative drive today. So all speculation that there must be this, there must be. He must come with evidence that this has happened and this has happened. From what is disclosed by the state, this has this effect that this has happened. It has happened, my lady. So, my lady, we cannot be. This court can be paged that it relies on speculation, my lady. My lady, the applicants have complained that, yes, we have received Part A of the docket, but in dribs and drabs. But the most important thing is that they have that docket. That is what is important. They have that docket. And explanation has been given in the answering affidavit why the audit report was delayed and why the disclosure was made as it was done. Because some of the documents, like it has been explained, are not part of the docket. They were at the instance of the accused persons. They were given. So now they can't come and say, we got disclosure late. No. If it was part of the docket, they can complain. But those documents are not part of the docket. They requested and they were given those documents. My lady, the Deloitte and Touch report was made available to the accused persons in June 2021. They seem to know they don't, but the explanation has been given in the answering affidavit. Why it was late? There were a few. It's mathematics, my lady. It's calculations involved there, and it's millions of dollars, hundreds of millions of dollars, which were moving up and down. So they just needed to fix those things. But they were made during the early stages when this matter was referred to the pre-trial conference, my lady. Well before the matter was referred to a trial judge. Well, years before. So they can't complain about it. That he doesn't consider it as a report, or he doesn't consider it as a forensic report. It's open to him too. He can give it any name what he wants to give, my lord, but the state refers to it as a report, my lord, as an audit report. And that's what is going to be relied upon by the state, my lady. That they put some, that they do not manage to interview the applicants and other accused persons. That is open to them to raise with the witnesses when they come to testify in this honorable court, my lady. And it can be part of this. And the most important thing is that the report and all the annexures thereto have been disclosed to the applicants. My lady, again, is the state sample submission that this application is dilatory. It's meant to delay the commencement or continuation of this trial. He has indicated to this court, we want this matter to go back to pre-trial conference. My lady, this matter came to pre-trial conference in this honorable court on the 21st of April, 2021. They were provided with the documentation, especially the docket, as per the court order, and the other documents followed a little bit later. And they were requested, and they're on court, they're court orders, my lord. And if this court proceedings, they're court orders where your predecessor judge in this matter, ask them, do you want to answer to the state's pre-trial conference memo or the documents filed by the state? All of them says, we don't want to do that. We're not going to respond. Some of the lawyers were saying, we have not read the docket, so it's of no use for us to respond to the pre-trial conference. Today is crying that he wants the matter to be referred back to the pre-trial conference. This matter was first appeared in the pre-trial conference in April 2021, and was there until October 2023, when it was supposed to start, trial was supposed to start. Nothing has been done to respond to the pre-trial conference memo by the state. They have not done so. They've been in possession of the docket. But today he's asking this court that he wants to go back to that procedure. If we go back to that procedure, if it took us 2 full years for the matter to be referred to trial from the pre-trial, we want us another 2 full years again before this matter can be tried. With due respect, my lady, this should not be allowed to happen. This matter must come to finality. Everyone wants this matter to come to finality. Even the accused persons, maybe accused number 1 and these co-applicants, they might not be interested in this matter being filed, but the rest of the other accused persons, they said they are ready for the matter to get to trial. Even accused number 1, who was then self-represented, he was ready to proceed to trial. My lady, it's a humble prayer to this honorable court by the state that any further dilatory measures should be rebuffed with the contempt they deserve. And this application must also be dismissed. It has no merit at law. If they couldn't make deals, that's not it. My lady, it's only that there are too many notices. My learned friend, his colleague, has just brought me to attention one of the notices. It was also signed on the 1st of August, 2025. he has put in a lot of notices, notice of motion in his papers, without indicating whether this one is amending or replacing the other, another notice of motion. Where paragraph 5 says, directing that the state furnishes the second, third, and sixth accused persons relating to and communication or written emails, SMSs, etc., and between the Anti-Corruption Commission and the special investigators of the Anti-Corruption Commission, duly appointed under Section 14 of the Anti-Corruption Commission, and before and after the concurrence of the Prime Minister, granted on 5 March 2020 and did in the delayed report of 9 June 2021. My lady, it's our submission that that also forms part of the diary, and in terms of Martha Siweda versus the state, that is that cannot be disclosed to the applicants. In any event, the state is not relying on that communication to prosecute them, but it relies on the evidence which has been disclosed to them. And paragraph 6 thereof says that directing that the state furnishes second and third applicants the following particulars: meetings of integrated investigation task force conducted in the investigation of the complaints registered with the Anti-Corruption Commission is put the case numbers as well as Windhoek CRs and the dates of the meetings and the attendance of the meetings. My lord, again, my lady, again, it's those information. Those people were not investigating. They were not investigators of this case, and that information is not part of the police docket or anti-corruption docket against the accused persons. And if this court finds that yes, it is part of the effort, but how would the minutes of those meetings, how would the attendance register of those meetings assist the accused persons in prosecuting their defenses? That has not been put on this on record by the accused persons, and it also falls in terms of state Siweda versus the state. It falls in issues, in matters which cannot be disclosed to the accused persons, my lady. So, in all, the documents which the accused persons are seeking to be disclosed to them, they are not entitled to those documents in terms of the law. What they are entitled to has been disclosed to them. And it's surprising, my lady, that we have 10 accused persons, but we have only 3 accused persons. Others are happy with the information which has been disclosed to them, which is enable them to prevail for that. They are facing the same charges. Even them might be facing lesser charges than the others, but they still want some more information which is not relevant. Others, they know the information is relevant. The information that is relevant has been disclosed for the preparation of the trial, my lady. My lady, let me just confirm with my lady friend. My lady, those are the state submissions, unless this honorable court wishes the state to address it only in a particular point, my lady.
Thank you.
Thank you, my lady.
Judge? May I request for a very important break of the day, lunch? I am a recipient of medication from the doctor I ingest. I must eat something to take that medication for my condition, I
Will
could do
2
that.
o'clock be sufficient time?
Excuse me, Judge?
It is now 1:20. Can we resume at 2 o'clock?
No, Judge. Could I, because I will then eat in a hurry, and could we resume at 1:15 if it is in your...
We will then resume 2:15.